Just give me a thumbs up when it's, oh, I see it. Never mind. Okay.
Okay, I think we're good to
Great.
go.
All right. So sorry, we're having a little technical difficulties here, but as long as you can hear me, that's all that counts. What you should be seeing on your screen is my zip forms. And thumbs up, Kim, that's what what everybody's seeing. Okay, great. All right. So this class is going to be on trust sales and probate sales. There are differences between them, and we're going to start with the easier of the two, and that's a trust sale. So I am going to I'm going to move you guys so that I can see my forms. All right. So if you're doing a trust sale, if either the buyer or the seller is buying or selling something that's in a trust, then you should be giving this form to your clients, be it buyer or seller. It's called a trust advisory, and it explains what a trust is. A trust is a property that's held in a revocable or irrevocable trust. The difference between revocable and irrevocable is one is you can revoke the trust or cancel the trust, and the other is you can't. For the benefit of those persons or entities named as beneficiaries to the trust, for the purpose of the sale of the property, the trustee of the trust is treated as the seller, even if the seller is exempt from some obligations. And I'll talk about exempt trustees a little later. Seller must comply with many, okay, never mind. This advisory is intended to inform buyer and seller of their rights. If a property is placed in a trust, any trustee must complete a TDS and other disclosures that would be required of any other owners if any such trustee is a natural person. That means if it is an actual individual, is as opposed to a corporation. And the trust is a revocable trust, and the trustee either is the former owner of the property or an occupant in possession of the property within the preceding year. Well, let's talk about that little caveat. The trustee either is the former owner of the property, or meaning prior to it was a trust, it was in this individual's name. That's what that means. So most people who have a trust or transfer a property over to a trust at one point had it in their individual names. You'll see that on Realist and whatnot. So, and the other thing of that was, or was an occupant in possession of property within the preceding year. So are we talking about kids who lived in the property 20 years ago? No. We're talking probably that little scenario if it was a rental, within the preceding year, or it's a divorce where that person, lived in it within the last year. They need to fill out the TDS. So that's what a trust is. Most people put the property in trust so to avoid probate, which is the other type of sale that we're going to talk about. So even if there are originating trustees, those are the people who created the trust. Now, when those people die, they name a beneficiary to the trustee or a successor trustee. So when those people pass away, the successor trustee takes over the trust and are allowed to sell the property on behalf of the trust. Now it's those successor trustees who are exempt unless they've lived in it in the last year or once was the owner of the property, the named owner of the property. So those people are exempt from doing a TDS and SBQ and whatnot. So, but they must comply with if they are exempt, they still are obligated to disclose no material facts affecting the value of the property. So if you're talking about a kid who kind of took care of mom and dad prior to passing away and arranged for the replacement of the heater or the replacement of the water heater or did something to the house, they're responsible, even though they're exempt from doing a TDS or any of that, they're still responsible for disclosing those types of things. So keep that in mind. They are not exempt from a natural hazard, NHD report. They're not exempt from smoke detectors, water heater, lead-based paint, smoke, carbon monoxide. This here gives the parameters for water conserving plumbing fixtures, the dates and whatnot. They're not exempt from a FERPTA. And then we go into if you are exempt, you still have to do certain things. You still have to do a seller, an ESD, exempt seller disclosure. That's C here right there. And that's the shortened version. Did anybody die on the premises and whatnot? So that's what a trust is. So before I move on, are there any questions? Handled in a sale. Well, let's look at, it's really easy. They've made it easy with the new form. And because they have incorporated the trust right into the new RPA. So you don't, it used to be you have to do a representative capacity. Well, you no longer have to do a representative capacity. But I'm going to back up. Sorry. So say the seller is selling the property and it is a trust. Sorry, you're probably getting dizzy from all this, but I just remembered where I wanted to go. Okay. Okay, the buyer signs. Okay. So the seller is the trust. So the name of the seller is the trustee. So if it's a regular trust, if it's an originating trustee, it would be Jane Doe, comma, co-trustee, if there's two of them or more than one, or John Doe, comma, co-trustee. If there's just one, John Doe, trustee. So that's the name of the seller. So print name of legalized authorized seller and their title, and that would be John Doe and the title trustee. So, and that's all you have to do with this form, because that is incorporated right into the form. You no longer have to do a representative capacity. And the same would hold true for a buyer, because the buyer's signature is set up, the same way. Entity buyers, from the name of the legally authorized buyers are, it's Jane Doe, trustee, or whatever, or whatever the name is, and then just put the name of the trust, and you're done. You're done for the buyers, and here for, where's the seller? Entity sellers, right there. So the names go here, and the name of the trust goes there. Now, we all know that the representative capacity can also be for attorneys, a power of attorney, or if it's a corporation or LLC, you would treat that way, but we're talking about trust right now, so I don't want to confuse you. So that's basically how you handle the sale if it's a trust. Everything else is just like a regular sale. It's exactly as a regular sale. Now, before I move on to probate, I will go over the representative capacity, because it still exists, because they haven't incorporated this into the listing agreement. My guess, this is for buyer, well, it's the same as buyer or the seller, but my guess is in June, when the new forms come out, it will be incorporated into the listing agreement also. So here's a representative capacity to tell that if this is a trust, and you say what it's, I'm going to go back because I actually want it to be for the seller. Hold on. There you go. All right, so you'd use this for the listing agreement. The listing agreement, and then the property, the address, between the listing broker, that would be us, whatever office you're with, and the seller. And once again, it's the names. It's Jane Doe trustee or co-trustee, John Doe trustee or co-trustee. If it is a successor trustee, I would write that it's a successor trustee. Once you get into escrow is going to ask for the trust paperwork and verify it. If you're ever in doubt, send your trust to, which you should be getting prior to taking a listing, by the way. If you see that it's in a trust, get a copy of that trust on the listing appointment, send it to title, make sure, are there any red flags here? Does anything need to be changed? So that's where you would put the names. Once again, I said, Jane Doe, John Doe, trustee or co-trustee, and then write the trust here. You'll have the copy of the trust. So you should be able to answer the question, because it asks when it's dated. So anyways, so that's a trust. We can go over entities and the other entities and whatnot at another time, because I don't want to muddy up we're talking about trust sales and probate sales. So any questions about trust sales? Because that's basically it. That is how it's handled, like any other sale. The representative capacity has now been incorporated into the RPA. I've just showed you, if you're using a listing agreement or anything, but let me go back. Sorry, because everybody is confused about this. So there's many different places to sign. They all don't have to be signed at the same time. So if you're taking a listing, it's signed down here. If at the time, then that same form, when it's sold, is signed here at the time of sale. So this one form can be used at different times within a transaction. And actually the buyer's form can be used. I think they add a buyer broker agreement on it. Other things, they add to it, but not everything has to be signed at the time it is created. I just wanted to point that out. So, okay. So any questions about trust sales? Remember, I can't hear you. So if you're talking, I can't hear you. So any questions, put in the chat, please. So I don't, I'm seeing one. Oh, that was Kim saying put questions in the chat. Okay. All right. So I'm going to move on to probate, which is a little more complicated. Okay. So I talk about this before I go on. I talk about this a lot. This is you see here, Forms Library, California Association of Realtors. This is a drop-down box. So all of your local association, I belong to a lot of associations. So every association that I belong to, they have their own set of addendums, and what Southland Regional is down here. Palm Springs, I belong to OC, all of this, they all have their own forms in zip forms. So I saw a question come up. I've done a few trust sales with the new RPA. Are you saying it's all incorporated in the RPA? So no need for representative capacity? That's exactly what I'm saying. But then you showed it. I only showed it because when you're doing a listing, you're still going to need the representative capacity. So I want to make sure that you knew how to fill it out in that instance. But if you're doing a trust sale, you don't need a representative capacity. It's incorporated in the form, which is great. So I just wanted to say that is a pull down. You go there for everything. And EPUBs, this is all your earthquake guides and lead-based paint and all that. They're all here. And the hazard report thing, that if the property is built 1960 or earlier, that needs to be filled out by the seller. And then the earthquake hazard, the guide, the receipt, that's here. So 5 and 6 are those two forms. Those are all the booklets, which you can send directly from your zip forms. And I talked about the any leases. A new lease, there is a form, which it's supposed to be in here. I'm not seeing it in regards to mold, but it's supposed to be here. Is it protector? Yeah, that's lead. That's it. Earthquake. Yeah. Oh, right here. Information on dampness and mold for renters in California. Any new lease, this automatically populates with a lease agreement. But if you're not using the CAR lease agreement, you have to give the tenant this booklet with any new leases, just new leases. Okay. So anyways, probate, on to probate. So once again, I'm in EPUBs and it's not going to show up there. Okay. So once again, there is an advisory for a probate sale. Now, probate, if a property isn't in a trust, then it's still going to have to go through probate in some manner, even if there's a will. It could be a simple filing of the will into the court, but everything that's not in a trust that transfers that way has to be filed through the courts in a probate. And like I said, it could be as simple as that. And you can have a probate sale that's just like any other sale, or you can have a more complicated one. So if it is a probate sale that requires court confirmation, because some do require court confirmation, then it's a little more complex. So the ones that there's a will and it's just a matter of filing it, and somebody has what you want is a letter that they have total authority, that the administrator has a total authority to sell that property on behalf of the estate. And if that is the case, it's like any other sale. You know, you have somebody who's authorized to sign on behalf of the estate, and it goes through like any other sale. So but they are exempt from some things. They don't have to do the TDS. They don't have to give the earthquake guide. It is, strangely enough, exempt from the state requirements for smoke detectors. You know, the seller is not exempt. There still is that they have the duty to disclose things that they know about the property, if they know something about the property, just like a trust sale. It's, once again, it's not exempt from an NHD. Water heaters, not exempt from that, not exempt from lead-based paint. Carbon monoxide, you know, strangely, you know, you don't have to put in a smoke detector, but you have to put in as a carbon monoxide detector. And then FERPTA, still, you know, and us as brokers, we're not exempt from doing an AVID. We still have to do that visual inspection. So that's excuse me, that's that. Now, with the new RPA, they have any general questions about probate before I move on to the actual paperwork for it? Not seeing any. Okay. So the new RPA, once the new RPA came out, they did away with the probate purchase agreement. You no longer, you can't even find it in zip forms. It no longer exists, the probate purchase agreement, but you use the regular RPA, and along with the regular RPA, there is a probate agreement purchase addendum. So it's filled out, you know, the top is filled out just like any, you know, the regular one. The property is part of a probate. Now, this also can be used for a conservatorship or guardianship or receivership, but we're just talking about probates today. It is being sold. We're not going to go through that. Okay. Okay. So once, like I told you, that there is the easy way of a probate, that somebody has full authority to sell it, and that's just handled exactly like any other sale. If it requires court confirmation, then here is what happens. An offer is accepted, and then that offer is accepted, the court is going to want 10% down. So if you're representing a buyer, they need to put down 10%. And that money is going to be tied up until the court confirms this sale. Now that can take up to 21 to 30 days in order to get that court date. So once the court date is received, this individual who won the court date, and most likely that will need to be no contingencies, a non-contingent offer, because financing needs to be in place. They should have done all of that prior to making this offer. You have all your ducks in a row. You're financed. You have your down payment. You have proof of funds for the rest of the down payment. You have all of that in line and ready to go. Then, when they get into court, the judge will say, we're here on the matter of probate number, for this property. We have an offer of, X amount of dollars, and do I hear anybody interested in overbidding? Now the court's going to determine what the overbid is prior to the court date. And you say, what do you mean by overbidding? My offer was accepted. Well, when it gets to court, it becomes an auction. So, and your buyer who won the bid better be ready to up his deposit, have a whole bunch of cashier's checks in hand to up his deposit in order to cover the new deposit, if he is the successful new bidder, if there are any additional bids. So it basically becomes an auction, and everybody needs to be ready, willing, and able on the spot to buy that property, no contingencies, to be able to close. This says within 10 days of the order. So that's why I said it needs to be ready to go when they sit in that courtroom. So, on this form, the addendum, it talks about seller may remove the property from the court calendar if the buyer has not removed all of their contingencies, or so that's why they want all contingencies to be removed up front. And you have to know how you're going to take the vesting at the time the offer is made. So I see it when these types of auction sales being done without contingencies, are these home at market value or below? They would be at market value. It's not an auction. Let's be clear. It's not an auction. It is a sale that is being confirmed by the court, and the court's duty is to get the most money for the estate. So at the time of the court confirmation, there is an opportunity for other ready, willing, and buyers to submit offers on the spot. So it becomes like an auction, but I say auction, but it's not an actual auction. It's a regular sale. So, but there, people may want to overbid what the winning bid was. Now, if you're a listing agent and you're doing a probate with court confirmation and you accept that offer, that listing needs to go into active under contract at that time, so it will be in active under contract until the court date. And a lot of listing agents, they'll just take whatever offer just to get it, get a court date. I don't suggest that. I suggest getting, because, then you get ticked off buyers and buyers agents because you had it so low, and then somebody went in there and they, and it's published as to what the winning bid was and what the increments are from there. So just know that. So if you represent a buyer whose offer is not accepted, they should show up at the court date with another shot to win. Sure. Yes. Yeah. To win the bid. So if the home does not require court confirmation, do you check 1B and it's a regular standard sale? This is in the way. 1B. Oh, I see. So you mean 3B1. So shall inform buyer at the time of acceptance or within 3, if court confirmation is required. Sure. Most likely it'll be in the MLS under private remarks. As to whether it is court confirmation or not. How would you know when to arrive to the court? No, you are given the date and the time of the court confirmation by the listing agent. Yes, the buyer's agent is given this information. In private remarks, do you post the accepted amount? How would they know how much to overbid? The court will determine how much the overbid is. And I think that they would put that in private remarks also, how much the overbid is, because remember, the listing agent is working with a probate attorney. They're not doing this on their own. So there is an attorney involved in this, and the attorney will let the agent know and whatnot. So if you're interested in doing probates, I suggest that you try to find a probate. It used to be easier when they were holding them in person. You could go down to the courthouse and sit and watch them. I don't know if you could really observe it now. You might be able to. I would research that. It'd be interesting to, to check it out, actually. You said multiple cashier's checks ready. How would they know how much to get it? They would be in $1,000 increments, because they are going to have to up their deposit depending on how far they're going to go. They know what their winning bid was, and so they should know what they're willing to go up to. So there's a difference there, and then you just do $1,000 increments of that difference of what you're willing to do, because who knows what the winning bid is going to be. So I think I've answered all those questions. It says here about the purchase price would be 90% of the probate appraised or reappraised value, unless exempt. If buyer defaults after court confirmation, the order confirming sale may be vacated. This may result in buyer's forfeiture of the full deposit. remember, you're going in with a non-contingent offer. So if you don't end up buying this when you go into court, then, you know, be aware that you may lose the deposit, which is basically in the possession of the court, and the court can pretty much do what they want. Uh, any other questions about this? Not seeing any. I'm trying to think. There is a probate listing addendum, and it basically is an informational addendum as part, you know, court confirmation, whether it is or isn't required. Anybody who's handling the estate for somebody would know if court confirmation is required. If they don't have that piece of paper saying that they have full authority to dispose of the personal and real property of the decedent, then it would be, you know, it would be needed. And if anybody has ever taken, you know, there's a lot of seminars, there's people who do seminars on probate sales. And if anybody has taken that, those seminars, you'd be surprised as to who goes through probate. Whitney Houston went through probate. Many, you know, well, I would guess that Prince went through probate because there was an issue with the will. So, you know, people who don't have their affairs in order, I mean, or they have partially in order. A lot of people will put their residence in trusts, but then they forget about their bank accounts and their investment accounts. Those are, you know, if your bank account isn't in your trust, then that has to be handled through probate. So everything you own should be in a trust. Just remember that. Does the buyer transfer the EMD within 3 days? Yes, they do. Is there any way to know the court date besides through the listing agent? Because I had a case where the listing agent was uncooperative. Court dates are public record. So you can search, you should figure out what court is handling the estate, and it would be on a docket. Joanne, yeah, because of, but I don't know that, because they won't allow you in the court, I don't know that they won't allow you to join via Zoom, because you may be a potential buyer. So I would look into that. I have a question about probate in general. How do you get these kind of listings? Become friends with probate attorneys. That's one way. I think I missed this, but when you said if the home will need, listing agent needs to submit for, the listing agent doesn't do this. As I said, the listing agent is working with an attorney. So they are hired by the attorney, and that's why you should get to know probate attorneys, because you know, my first brokerage, there was an agent who just did probates, and she would get these listings from, you know, attorneys that she knew, and they trusted her, and they knew that she would do a good job and whatnot, and she got all these listings of probates. So that's how you do it. Your bank accounts held in a payable upon death, which lists your beneficiary, it is okay. If you have a POD, payable on death, it doesn't have to be in a trust, but a lot of people don't have it in a POD. They just have a bank account. And even if it's a joint bank account, I was joined on my mother's bank account, and there was still issues of dealing with the bank right after she passed away because she was still on the account. So I mean, it doesn't make sense. You would think it's it'd be automatic. Oh, I'm on the account, but it's not that way. So get a good estate attorney or estate planning attorney. They will allow Zoom, Joanne. Oh, good. Where do you find the ability to go? Well, Joanne, tell Sylvia where she needs to go. Sound like a game show host. Tell them where they get to go. Unless they do pro bono. Okay. Okay. So I really don't have that much more on probate. I mean, it's not as scary as everybody thinks it is. I mean, it's not. I mean, most probates, somebody is authorized to dispose of the property, without going to court. But there are those people who have to go to court. And in those rare instances, it becomes a little more complicated. So, but they are, for the most part, handled just like any other sale. The one thing I want to stress, because this came up this week in regards to trusts, I had somebody say, well, a trust, I have to change the name of the trust. We're in escrow and now I have to change the name. I represent the seller. I have to change the name of the trust. And it's like, I'm thinking to myself, why are you changing the name of the trust when you're in escrow? They're saying that what's in Realist, what's on the public records, isn't correct. That's not the real name of the trust. That would make my spidey senses go up, because what is on record and filed with the city isn't right. So when you're going out on listing appointments, Realist is your friend. They know that they list who the owner is, and for the most part, you can actually pull the document from Realist. You can see the trust from Realist. There's a link to there's a code and there's a link and you can pull it. So you should know when you're doing a listing agreement who is authorized to sign paperwork to put that property on the market. And you should do your paperwork accordingly. And I will also say, agents represent buyers. Don't be lazy. Don't leave the seller's name off. You have access to this information. If you're writing an offer, it should be the cleanest offer that you could, because you want your offer accepted. That's what I would do when I was writing offers. I would want to make the least bit of hassle to the listing agent. Hey, what services are you using? What escrow company are you using? I'll write it in the contract. So they have very little to counter you. And the one thing that you should have on that contract is who the seller is. I can't tell you how many RPAs I'm being sent where that's being left off. And that's just not, that's your job. You need to fill that in, and it's available to you. So I think that's it for now, unless anybody has any other questions. This class was suggested to me by Deborah Bell. She said a lot of people have questions about trusts and probates, and so I added this class. So if anybody ever has any questions, any suggestions as to what they want a class to be, let me, shoot me an email. I'll consider it, absolutely. If I think it'll benefit the offices. I'm always open. I do 2 classes a month, and I can only teach disclosures and RPA so many times. So if you want to learn new things or hear about new things, I'm ready, willing, and able. So so unless anybody has anything else, I'm going to say adios. All right. Thank you.
Thank
Take
you.
care.
Thank you, Rich.
Thank you.
Thank you, everyone, for joining.